Today on Legalese, I will be figuratively filleting Associate Justice Neil Gorsuch as we discuss his truly inspiring statement from the recent case of Arizona v. Mayorkas and the so-called Title 42 emergency orders. Hey, greetings everybody. Welcome back to Legalese. I am your host, Bob. Thank you so much for joining me here today. Now, if you happen to be new to my channel, let me bid a special welcome to you. This is the podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. So today's video that I have is it's a little different from what I would usually do, but I came across a statement written by Associate Justice Neil Gorsuch in the case of Arizona v. Mayorkas that I just really wanted to share with you guys because I think it really touches on a number of larger issues that are really a staple of my channel, such as the dangers of emergency powers granted to government because we let fear and a desire for security lead us into emotional choices where we so often find ourselves demanding the government take away from us the very rights and liberties that represent the best of American values and ideals. We also see federal, state, and local governments, and often even, in many cases, individual citizens who will use these powers to take it upon themselves to turn into petty tyrants, pocket dictators, and ad hoc authoritarians. And it shows how once these powers are issued to take care of a very specific issue, such as the COVID-19 pandemic, they will always be usurped by government for their own ends. In particular, I am talking about the Title 42 orders that were put in place to limit immigration to prevent the spread of COVID. Because even after pretty much every facet of government recognized that original danger had passed, that the Title 42 emergency orders were put in place to guard against, what we saw was many state governments trying to usurp these powers for unintended purposes. You see, many states agreed that the Title 42 orders passed to prevent COVID were no longer needed for that purpose, but that a new epidemic had emerged, they say, that being the supposed invasion at our southern borders. Now, regardless of where you stand on our issues with immigration, the fact that many states were filing suit to keep these orders in place indefinitely for reasons completely beyond the scope of their intended purpose is a kind of tyranny that should simply never be tolerated. So, finally, this statement speaks to issues with the modern administrative state as well, and these are issues that have been the main focus of my last two videos. And what you see is two different administrative agencies, namely the Department of Homeland Security and the Department of Health and Human Services, abusing the Administrative Procedures Act, which, if you guys may recall, is the statute I talked about in my last video in great detail that governs how the administrative state judicial review process is supposed to work, and specifically that this is a law that uses a high degree of judicial deference, and the statute grants to these agencies all deference should be given as long as their interpretation of the statute provided is not arbitrary or capricious. But what we saw here happen with this was we saw two different administrative agencies using the same order in two different circuit courts to get nationwide injunctions issued that directly conflicted with each other. And what happened is when this first occurred, we saw the Supreme Court choosing to just let this abuse go on for about a good solid 6 months before they finally agreed to take up the case and address the issue, and only because it now became clear that the arguments being made were moot and there was no risk of backlash for stating as much and vacating these orders. So the court issued a procedural order in this case, and Justice Gorsuch wrote a statement regarding that decision. Now, it began by laying out the tortured procedural history and noting problems posed by nationwide injunctions. But then a little ways down the page, you see at the last paragraph here, he starts with the following statement. Since March of 2020, we may have experienced the greatest intrusion on civil liberties in the peacetime history of this country. Executive officials across the country issued emergency decrees on a breathtaking scale. Governors and local leaders imposed lockdown orders, forcing people to remain in their homes. They shuttered businesses and schools, both public and private. They closed churches, even as they allowed casinos and other favored businesses to carry on. They threatened violators not just with civil penalties, but criminal sanctions too. They surveilled church parking lots, recorded license plates, and issued notices warning that attendance at even outdoor services satisfying all state social distancing and hygiene requirements could amount to criminal conduct. They divided cities and neighborhoods into color-coded zones. They forced individuals to fight for their freedoms in court on emergency timetables, and then changed their color-coded schemes when defeat in court seemed imminent. Federal executive officials entered the act too. Not just with emergency immigration decrees, they employed a public health agency to regulate landlord-tenant relations nationwide. They used a workplace safety agency to issue a vaccination mandate for most working Americans. They threatened to fire non-compliant employees and warned that service members who refused to vaccinate might face dishonorable discharge and confinement. Along the way, it seems federal officials may have pressured social media companies to suppress information about pandemic policies with which they disagreed, while executive officials issued new emergency decrees at a furious pace. State legislatures and Congress, the bodies normally responsible for adopting our laws, too often fell silent. Courts, bound to protect our liberties, addressed a few, but hardly all of the intrusions upon them. In some cases, like this one, courts even allowed themselves to be used to perpetuate emergency public health decrees for collateral purposes, itself a form of emergency lawmaking by litigation. Doubtless, many lessons can be learned from this chapter in our history, and hopefully, serious efforts are made to study it. One lesson might be this: fear and a desire for safety are powerful forces. They can lead to a clamor for action, almost any action, as long as someone does something to address a perceived threat. A leader or an expert who claims that he can fix everything if only we do exactly as he says can prove an irresistible force. We do not need to confront a bayonet. We only need a nudge before we willingly abandon the nicety of requiring laws to be adopted by our legislative representatives and accept rule by decree. Along the way, we will accede to the loss of many cherished civil liberties, the right to worship freely, to debate public policy without censorship, to gather with friends and family, or simply leave our homes. We may even cheer on those who ask us to disregard our normal lawmaking processes and forfeit our personal freedoms. Of course, this is no new story. Even the ancients warned that democracies can degenerate towards autocracy in the face of fear. He cites Aristotle's Politics. But he says maybe we have learned another lesson too. The concentration of power in the hands of so few may be efficient and sometimes popular, but it does not tend towards sound government. However wise one person or his advisors may be, that is no substitute for the wisdom of the whole of the American people that can be tapped in the legislative process. Decisions produced by those who indulge no criticism are rarely as good as those produced after robust and uncensored debates. Decisions announced on the fly are rarely as wise as those that come after careful deliberation. Decisions made by a few often yield unintended consequences that may be avoided when more are consulted. Autocracies have always suffered these defects. Maybe, hopefully, we have relearned these lessons too. In the 1970s, Congress studied the use of emergency decrees. It observed that they can allow executive authorities to tap into extraordinary powers. Congress also observed that emergency decrees have a habit of long outliving the crises that generate them. Some federal emergency proclamations, Congress noted, had remained in effect for years or decades after the emergency in question had passed. At the same time, Congress recognized that quick, unilateral executive action is sometimes necessary and permitted in our constitutional order. In an effort to balance those considerations and ensure a more normal operation of our laws and a firmer protection of our liberties, Congress adopted a number of new guardrails in the National Emergencies Act. Despite that law, the number of declared emergencies has only grown in the ensuing years, and it is hard not to wonder whether, after nearly half a century, and in the light of our nation's recent experience, another look is warranted. It is hard not to wonder, too, whether state legislatures might find profitably re-examine the proper scope of emergency executive powers at the state level. At the very least, one can hope that the judiciary will not soon again allow itself to be part of the problem by permitting litigants to manipulate our docket to perpetuate a decree designed for one emergency to address another. Make no mistake, decisive executive action is sometimes necessary and appropriate. But if emergency decrees promise to solve some problems, they threaten to generate others. And rule by indefinite emergency edict risks leaving all of us with a shell of a democracy and civil liberties just as hollow. Well, that's really all I got for you guys today. I really hope you enjoyed that statement and found it as interesting and inspiring as I did. If so, maybe take a moment to do all of those things that help me trigger Al Gore's rhythm. If you liked the video, hit the like button. If you disliked it, hit the dislike button. Let me know what you thought about this topic in the comment section down below. And, maybe if you feel like it, consider subscribing to the channel so you always get updates on when new content comes out. And of course, if you want to read this whole statement, including the initial part I skipped over about the procedural history of this law, I will have that linked in the video description as well. So, until next time, this has been Bob for Legalese, and as always, Carthago delenda est.
Motherfucker, like Freddie Mercury. Motherfucker. got a trunk full of amps, brother.